56% of Americans believe they have the right to a free lawyer in civil court cases. A Harris Poll survey of over 2,000 adults found that more than half the country is walking around with this wrong belief. They think the court will give them a lawyer for free. And when they show up to court without one, they get destroyed. Research from Cornell Law School found that people who represent themselves in federal court only win about 3% of the time as plaintiffs. 3%. That's not a typo, that is real. And this video is going to change that for you. Because today, I'm going to walk you through the entire court system from start to finish in plain language. No fancy lawyer words, no tricks, just the truth about how courts work, who's in them, what they do, and most importantly, how you can protect yourself inside of one. Because here's the thing nobody tells you. The Vera Institute of Justice found that being held in jail before your trial, just waiting, increases your chances of pleading guilty by 46%, almost half. The system doesn't just punish guilt, it punishes confusion. It punishes people who don't understand the rules. And by the end of this video, you will understand the rules. So stay with me. Every single minute matters. Let me tell you why this is urgent. A nationwide survey by Isles and Hill that reached 10,000 Americans found that 66% of the population experienced at least one legal issue in the past 4 years. 2 out of every 3 people. And only 49% of those problems were completely resolved. That means more than half of all legal problems in America just hang there, unfinished, unresolved, eating away at people's lives. And these aren't rare situations. These are things like a landlord refusing to return your deposit after you moved out, a hospital sending you a bill for $12,000 that your insurance was supposed to cover, your ex refusing to follow the custody agreement. Real-life problems that end up in real courts. And the scariest part? The Legal Services Corporation found that many Americans who did experience a civil legal matter didn't even seek legal help. They just accepted it. They gave up because they didn't know the system. Today, that changes. Let's start from the very beginning. The first thing you need to know is that there isn't just one court system. There are 2. The U.S. Constitution creates a federal system where power is shared between the federal government and the state governments. Both the federal government and each of the state governments have their own court systems. That's right, 2 separate systems running at the same time, side by side. Think of it this way. The federal court system is like the national team. It handles the big stuff that affects the whole country. Things like someone smuggling drugs across state lines, a company committing tax fraud against the IRS, or 2 businesses from different states suing each other over a $1 million contract. That goes to federal court. The state court system is like your local team. It handles things that happen inside your state. Things like a car accident on your city's highway, a divorce between 2 people living in the same town, or someone breaking into a house 3 blocks from your home. That goes to state court. And here's something wild. Most of the cases that affect your daily life, they happen in state court, not federal. Remember that. Now let me break down the state court system because this is where you are most likely to end up. Every state has its own setup. Florida sets up its courts one way. California does it another way. New York does it a completely different way. But they all share the same basic structure. 3 levels. Think of a ladder with 3 steps. The bottom step is called the trial court. Some people call it the court of general jurisdiction. According to Study.com's legal education materials, these are the courts that handle criminal cases, civil cases, and even traffic cases. This is where things start. This is where a jury hears the evidence about whether someone actually stole that car, or whether a company actually failed to pay its workers. The middle step is the appellate court. If you lose at the trial court level and you think the judge made a mistake, you can appeal. You take your case up to the appellate court. But here's the thing. The appellate court does not retry the whole case. They don't bring in new witnesses. They just look at the paperwork and the law to see if the trial court got it wrong. And the top step? That's the state Supreme Court, the final word in that state. If they say no, it's over. Unless, and I'll tell you about this later, your case involves the U.S. Constitution. Now let's go to the other side, the federal court system. The Department of Justice explains that federal courts handle cases that involve federal laws, the U.S. Constitution, and disputes between people from different states where the amount of money involved is more than $75,000. That last one is called diversity jurisdiction. Remember that term. The federal system also has 3 levels. At the bottom, you have 94 district courts spread across the country. The NAACP's legal guide confirms there are 94 of these trial courts covering all 50 states, the District of Columbia, Guam, Puerto Rico, the U.S. Virgin Islands, and the Northern Mariana Islands. This is where federal trials happen. Above that, you have 13 courts of appeals, also called circuit courts. These are the federal version of appellate courts. The Department of Justice notes that each circuit court has multiple judges, ranging from 6 on the First Circuit to 29 on the Ninth Circuit. And at the very top sits the United States Supreme Court, 9 justices, the final word on the law of the land. They hear very few cases, but when they speak, everyone listens. Now, here's where it gets really interesting. And I need you to pay close attention here because this one concept confuses more people than almost anything else in law. It's called jurisdiction. The Legal Information Institute at Cornell Law defines jurisdiction as the power of a court to hear a case and make a decision. Without jurisdiction, the court cannot touch you. It literally has no power over your case. There are different types of jurisdiction. Subject matter jurisdiction means the court has authority over the type of issue. A bankruptcy court can hear your bankruptcy case, but it cannot hear your divorce case. That's not its subject. Then there's territorial jurisdiction, which is about geography. A court in Texas usually can't make decisions about something that happened entirely in Nigeria. The event has to be connected to that court's territory. And here's the secret that lawyers use every day. If a court doesn't have jurisdiction, nothing it does matters. Imagine a judge in a small-town traffic court tries to rule on a federal immigration case. That ruling means nothing. 0. It's void. It's like a referee from basketball trying to give a red card in a soccer game. They don't have the authority. Jurisdiction is everything. Now let's talk about the 2 big categories of cases: criminal cases and civil cases. This is something most people mix up, and once you understand the difference, the whole system starts to make sense. A criminal case is when the government says you broke a law. The government is always one of the parties. So if someone robs a store, it's not store owner versus robber. It's the state of California versus robber, or the United States versus robber. The government brings the charges. The government hires the prosecutor. And if you're found guilty, the punishment can include jail time, fines, or probation. A civil case is different. A civil case is a dispute between 2 people, 2 companies, or a person and a company. Your neighbor's dog bites you, and you want them to pay your hospital bill. That's civil. A company fires you illegally because of your race. That's civil. You lend your friend $5,000 and they refuse to pay it back. That's civil. In civil cases, nobody goes to jail. The losing side usually pays money. It's called damages. Keep this difference in your head. Criminal equals potential jail. Civil equals potential money. Let's talk about the people inside a court case. Because every case has at least 2 sides. In a civil case, the person who starts the lawsuit is called the plaintiff. The person being sued is called the defendant. So if Maria sues her landlord because he won't fix the broken pipes in her apartment, Maria is the plaintiff and the landlord is the defendant. In a criminal case, the side that brings the charges is called the prosecution. That's the government. The person accused of the crime is still called the defendant. So if the state of New York charges someone with assault, the state of New York is the prosecution, and the accused person is the defendant. And there are other people in the courtroom, too. The judge, who controls the proceedings and makes sure everyone follows the rules. The jury, if there is one, which decides the facts. The clerk, who handles the paperwork. The bailiff, who keeps order. And the court reporter, who writes down every word that is said. Every single one. It's all recorded. That transcript can be used later in an appeal. Nothing disappears in court. A lot of people think judges just sit there and bang a gavel. That is so far from the truth. Judges are the most powerful people in the courtroom. They decide what evidence is allowed. They decide what questions lawyers can ask. They interpret the law and explain it to the jury. And in some cases, there is no jury. The judge decides everything alone. That's called a bench trial. Federal judges are especially powerful because, according to the U.S. Constitution, they hold their positions for life. They can only be removed through impeachment. That means once a federal judge is appointed, they can serve until they die, retire, or get impeached. Throughout history, only 15 federal judges have ever been impeached. State judges are different. In many states, judges are elected, meaning regular people vote for them, just like they vote for a mayor or a governor. In some states, judges are appointed by the governor. The way a judge gets their job can affect how they make decisions. This is something most people don't think about, but it matters a lot. Now let's talk about juries, because this is one of the most unique things about the court system. The Willow Research Study found that while 62% of Americans agree the jury system is still the best way to resolve disputes, that number dropped from 82% back in 2002. That's a big decline. People are losing faith. But here's how it works. A jury is a group of regular people, usually 12 in criminal cases and 6 in civil cases, who are chosen to listen to the evidence and decide what the facts are. They hear the witnesses. They see the documents, they watch the surveillance footage, and then they go into a private room and decide, is this person guilty or not guilty? Did this company cause harm or not? The power of the jury is that it puts the decision in the hands of ordinary people, not lawyers, not politicians, ordinary people. Your jury could include a bus driver, a school teacher, a nurse, and a retired construction worker. These are the people who decide your fate. But here's the important thing I'll explain later. How those jury members are chosen can make or break your entire case. Now, this is the part most people never learn about, and it might be the most important part of this entire video. The American Bar Association released a massive report that found nearly 98% of convictions nationwide come from guilty pleas. NPR reported that in any given year, 98% of criminal cases in federal courts end with a plea bargain. That means almost nobody goes to trial. Almost nobody. A plea bargain is a deal. The prosecutor says, if you plead guilty to a lesser charge, we'll recommend a shorter sentence. Imagine you're charged with armed robbery, which carries 15 years in prison. The prosecutor offers you a deal. Plead guilty to simple theft, and you get 2 years. Many people take that deal, even if they're innocent, because the risk of losing at trial is too terrifying. The Vera Institute found that people are 25 percentage points more likely to plead guilty when faced with the death penalty, and the odds of receiving a plea offer that includes jail time are almost 70% greater for black people than white people. The American Bar Association itself stated that plea bargaining accounts for almost 98% of federal convictions and 95% of state convictions. The system wasn't designed this way, but this is what it became. So why are trials disappearing? Well, think about it from the court's perspective. There are millions of cases every year. In just one state like New York, the courts reported 1.8 million people appeared without any legal representation, according to the Legal Services Corporation. The system is drowning. There aren't enough judges, enough courtrooms, or enough time to give everyone a full trial. The ABA Plea Bargain Task Force explained that plea bargaining exploded because of the over-criminalization of the early 20th century. When Prohibition made alcohol illegal, federal cases jumped to 8 times the previous number. Courts couldn't handle it, so they started making deals, and that practice never stopped. Today, some counties have literally 0 trials. Santa Cruz County in Arizona had no trials from 2010 to 2012. None. States like Pennsylvania, Texas, and New York have trial rates of less than 3%. The trial, which is supposed to be the cornerstone of justice, has become what the ABA calls a rare legal artifact. That should concern everyone. Now, let me walk you through what actually happens in a civil case, step by step. Because knowing the steps is like having a map, and a map prevents you from getting lost. Step 1. The plaintiff files a complaint. This is a document that says who you are suing, why you are suing them, and what you want. So if you're suing a car company because a defective brake caused you to crash, your complaint would name the company, explain how the brake failed, and ask for $200,000 to cover your medical bills, lost wages, and pain. You file this paper with the court, and the court gives the defendant a copy. This is called service of process. Step 2. The defendant files an answer. This is their response. They can admit things, deny things, or raise what's called affirmative defenses. An affirmative defense is basically the defendant saying, even if what you say is true, I'm still not legally responsible because of this reason. For example, the car company might say, you modified the brakes yourself after purchase, so it's your fault. That's their defense. And from here, the battle begins. Step 3 is called discovery, and this is where cases are won or lost. Discovery is the phase where both sides get to demand information from each other. You can ask the car company for their internal emails about the brake design. You can force their engineers to sit down and answer your lawyer's questions under oath. That's called a deposition. Discovery includes things called interrogatories, which are written questions the other side must answer in writing and under oath. It includes requests for production, where you ask for documents, photos, videos, or any other evidence. And it includes requests for admission, where you ask the other side to admit certain facts so you don't have to prove them at trial. This phase can last months, sometimes years, and it's expensive. This is where a lot of cases settle, because once both sides see all the evidence, one side usually realizes they're going to lose. The car company sees their own emails saying, we know the brake has a defect, but fixing it would cost too much. At that point, they'd rather pay you to go away than let a jury see those emails. Settlement. And just like that, the case never reaches a courtroom. But if the case doesn't settle, we go to trial. And the trial follows a very specific order. First comes jury selection, which is called voir dire. Both sides ask potential jurors questions to figure out if they have any biases. The plaintiff's lawyer might ask, do any of you work for a car company? The defendant's lawyer might ask, has anyone here been in a car accident and sued someone? They're looking for people who will be fair. Then come opening statements. Each side tells the jury what they expect the evidence to show. This isn't evidence itself, it's a preview. Think of it like a movie trailer. Then, the plaintiff presents their case first. They call witnesses, show documents, and try to prove their claims. After that, the defendant gets to do the same thing. Then come closing arguments. Each side summarizes everything and tells the jury why they should win. Finally, the jury goes into a private room, talks about everything they heard, and makes a decision. In civil cases, that decision is usually based on a preponderance of the evidence. That means, is it more likely than not that the plaintiff is right? It's not beyond a reasonable doubt like in criminal cases. It's just which side is more believable. More than 50%. That's the standard. Now let's flip to criminal cases, because the process is different and the stakes are much higher. A criminal case starts when someone is arrested or when a grand jury issues an indictment. An indictment is a formal accusation that says there's enough evidence to charge someone with a crime. After the arrest comes the arraignment. This is your first appearance in front of a judge. The judge reads the charges against you. They say something like, "You are charged with aggravated assault with a deadly weapon." And then they ask you the most important question of your life. How do you plead? You can say guilty, not guilty, or no contest. This is also where bail gets decided. Bail is the money you pay to get out of jail while waiting for your trial. The judge looks at things like how serious the crime is, whether you're a danger to the community, and whether you might run. If you're charged with shoplifting a jacket and you have a stable job and a family nearby, the judge might set bail at $1,000, or even let you go without paying anything. But if you're charged with murder and you have a passport from another country, bail could be set at $1 million, or denied completely. Now here is where I need you to really understand something. Your rights before trial can affect everything that happens later. In criminal cases, you have the right to an attorney. If you cannot afford one, one will be appointed for you. This comes from the Sixth Amendment of the U.S. Constitution and the famous case Miranda versus Arizona. But remember what I said at the beginning? That right to a free lawyer applies only to criminal cases. The Harris Poll survey for the Legal Services Corporation found that 56% of Americans wrongly believe they get a free lawyer in civil cases too. And among younger adults ages 18 to 34, that number jumps to 67%. Almost 7 out of 10 young people believe something that is completely false. This matters because the IAALS found that at least one party is unrepresented by an attorney in at least 75% of state court cases, 3 out of 4 cases, and the outcomes are devastating. People without lawyers get evicted, lose custody, and have their wages taken, all because they didn't know they needed to find help on their own. The court won't do it for them. Let's talk about evidence, because evidence is the fuel that runs the entire courtroom engine. Without evidence, you have nothing. Evidence is anything that helps prove or disprove a claim. Documents, photos, videos, text messages, emails, physical objects, and testimony from witnesses. But not all evidence gets in. There are strict rules. The rules of evidence control what the jury can see and hear. If a police officer searched your house without a proper warrant, anything they found might get thrown out. That's called the exclusionary rule. The evidence exists, the judge knows it exists, but the jury never sees it, because it was obtained illegally. There's also something called hearsay. Hearsay is when someone tries to tell the court what another person said to prove that what the other person said is true. Your friend can't walk into court and say, "Well, my cousin told me he saw the defendant steal the car." That's hearsay. Your friend didn't see it. They're just repeating what someone else told them. And in most situations, the court won't allow it. There are exceptions to the hearsay rule, but that's a whole other video. Now, burden of proof. This is the invisible force that determines who wins and who loses. The burden of proof means whose job is it to prove their case, and how much proof do they need? In a criminal case, the burden is on the prosecution. The government must prove the defendant is guilty beyond a reasonable doubt. That is the highest standard of proof in the legal system. It doesn't mean 100% certainty, but it means the evidence is so strong that a reasonable person would have no serious doubt about guilt. If even one juror looks at all the evidence and thinks, I'm not fully sure, that's reasonable doubt. In a civil case, the standard is much lower. The plaintiff only needs to show a preponderance of the evidence. That basically means more likely than not. Think of a scale. If the plaintiff's evidence is even slightly heavier than the defendant's, the plaintiff wins. Some civil cases use an in-between standard called clear and convincing evidence. This comes up in cases like fraud or defamation, where the claim is serious but not criminal. Know these standards. They are the invisible rules that shape every courtroom outcome. What happens when you lose? Is it over? Not necessarily. You have the right to appeal. An appeal is when you go to a higher court and say, "The lower court made a mistake." But here's what most people get wrong about appeals. You cannot appeal just because you didn't like the result. An appeal must be based on a legal error. The judge gave the jury the wrong instructions. The judge allowed evidence that should have been excluded. The judge applied the wrong law. Those are reasons for appeal. "I think the jury got it wrong" is not a reason. The appeals court does not look at the facts again. They only look at the law. And here's something else. The Department of Justice explains that a federal appeal is heard by a panel of 3 circuit court judges. Both sides file written arguments called briefs. Then the lawyers appear for oral argument, where the judges ask questions. The judges then decide whether to affirm the lower court's decision or reverse it. And if you still lose after the appeal, in some cases, you can take it all the way up to the Supreme Court. But they only accept about 70 to 80 cases per year out of thousands of requests. Now, not every court case has to be a big, dramatic battle. There's a court specifically designed for small, everyday disputes. It's called Small Claims Court, and this might be the most useful court for regular people. Small Claims Court handles things like a mechanic charging you $2,000 for repairs they never actually did, or a friend who borrowed $3,000 and ghosted you, or a dry cleaner that ruined your $800 suit. The dollar limit varies by state. In some states, you can sue for up to $5,000. In others, up to $10,000 or even $25,000. The best part? You usually don't need a lawyer. In fact, in some states, lawyers are not even allowed in small claims court. You just fill out a form, pay a small fee, show up on your court date, tell the judge what happened, show your evidence, and the judge decides. It's fast, it's cheap, and it's designed for people who are not lawyers. If someone owes you money or cheated you on a service, this is your first stop. Remember that. Family court is a whole different world. This is where divorce, child custody, child support, adoption, and domestic violence cases are handled. And it is one of the busiest parts of the court system. If 2 parents are fighting over who gets the kids on weekdays versus weekends, that's family court. If a mother wants to increase child support because the father got a big promotion, that's family court. If someone needs a restraining order because their partner is violent, that's family court. The standard in family court is different from other courts. When it comes to children, the court always asks one question above all others. What is in the best interest of the child? Not the best interest of the mother, not the best interest of the father, the child. The judge looks at things like who has been the primary caretaker, which parent provides a more stable home, what the child wants if they're old enough to express a preference, and whether either parent has a history of abuse or substance problems. Family court is emotional, it's personal, and understanding how it works can protect your family. When someone dies, their stuff doesn't just magically go to their family. There's a court process for that. It's called probate. Probate court handles the distribution of a dead person's money, property, and possessions. If your grandmother passes away and leaves behind a house, a bank account with $50,000, and a car, probate court decides who gets what. If she left a will, the court follows the will. If she didn't leave a will, the court follows the state's laws on who inherits. Usually that means the closest relatives, spouse first, then children, then parents, then siblings. Probate can take months or even years, and it costs money. There are court fees, lawyer fees, and sometimes taxes. This is why people create things called trusts. A trust allows you to pass your property to your family without going through probate court. It's faster, it's private, and it's cheaper. If you own anything of value, having a trust or at minimum a will is one of the smartest legal moves you can make. We'll talk more about protecting yourself later. Bankruptcy court exists for people and businesses who cannot pay their debts. Federal bankruptcy courts handle these cases because bankruptcy is a federal law, not a state one. There's a type called Chapter 7, where the court wipes out most of your debts, but you might have to give up some property. Then there's Chapter 13, where the court creates a payment plan so you can pay back some debts over 3 to 5 years while keeping your house and car. And for businesses, there's Chapter 11, which lets a company reorganize its debts and keep operating. Bankruptcy is not the end of the world. Millions of people file for it. It stays on your credit report for 7 to 10 years, but it gives you a fresh start. The key is knowing which type fits your situation. And here's something people don't realize. Once you file for bankruptcy, something called an automatic stay kicks in. That means creditors must stop calling you, stop suing you, and stop trying to take your stuff. Immediately. The court orders it. That's the power of understanding how courts work. Immigration court is one of the most misunderstood courts in the system. It's a federal court that handles cases about whether someone can stay in the country or must be removed. But here's the tricky part. Immigration court is not part of the judicial branch. It's run by the Department of Justice, which is part of the executive branch. That means the same government trying to deport you is also running the court that decides your case. If someone crosses the border without documents, or overstays their visa, or applies for asylum because their home country is too dangerous, their case goes to immigration court. An immigration judge decides whether they can stay or must leave. And unlike criminal court, there is no guaranteed right to a free lawyer in immigration court. Children as young as 3 years old have appeared in immigration court without a lawyer. Organizations have tried to provide volunteer lawyers, but the need far outweighs the supply. Understanding that immigration court is separate from the regular court system is critical if you or anyone you know is dealing with immigration issues. Let's talk about lawyers, because people either love them or hate them. But understanding what they actually do can save your life, or at least save your money. A lawyer's job is to represent you. They speak for you. They write your documents. They argue your case. They know the rules, the laws, and the procedures. Think of it like a guide in a foreign country. You could try to navigate a city where you don't speak the language and don't know the roads. But having someone who does makes everything easier and safer.
There are different types of lawyers for different types of cases. Criminal defense lawyers help people accused of crimes. Personal injury lawyers help people who were hurt because of someone else's carelessness. Family lawyers handle divorce and custody. Estate lawyers handle wills and trusts. Corporate lawyers help businesses. Immigration lawyers handle visa and deportation cases. You wouldn't go to a foot doctor for a heart problem. Same thing with lawyers. Get the right one for your situation. Here's how you actually find a lawyer, because knowing you need one is only half the battle. First, many lawyers offer free consultations. That first meeting costs you nothing. They listen to your case and tell you if they can help. Second, many personal injury lawyers work on contingency. That means you pay nothing up front. The lawyer only gets paid if you win. They take a percentage, usually 33% to 40% of whatever money you receive. So if you win $100,000, the lawyer takes about $33,000 to $40,000. If you lose, you owe them nothing. Third, if you can't afford a lawyer at all, there are legal aid organizations in every state that provide free legal help to low-income people. The Legal Services Corporation is the largest funder of civil legal aid in the country. They support 129 legal aid organizations across all 50 states. Lawhelp.org connects low-income people with free legal resources in their area. And many law schools run free legal clinics where law students handle real cases under a professor's supervision.
The help is out there. You just have to look for it. Now, can you represent yourself? Yes, legally you can. It's called going pro se. But should you? The numbers tell a scary story. Research from Cornell Law School found that pro se plaintiffs in federal court won only about 3% of their cases. Pro se defendants? About 12%. Compare that to cases where both sides have lawyers. The University of Chicago Law Review found that when both sides are represented, each side wins roughly 50% of the time. 50%. That's fair. But when one side has a lawyer and the other doesn't, the playing field is completely tilted. The Self-Represented Litigation Network reports that 60 to 100% of cases in state courts today involve at least one self-represented party. And a Cornell study found that 56% of pro se claims couldn't even survive a preliminary motion to dismiss. That means the case got thrown out before it even reached a courtroom. It's like showing up to a chess tournament without knowing how the pieces move. You might be right about your case, but if you don't know the rules, being right won't save you. Here's some good news. You don't always have to go to court. There are other ways to settle disputes. Two of the most common are mediation and arbitration. Mediation is when both sides sit down with a neutral person called a mediator. The mediator does not make a decision. They help both sides talk and try to reach an agreement on their own. So if you and your business partner disagree about who owns what percentage of the company, a mediator helps you work it out. If you reach an agreement, great. If not, you can still go to court. Arbitration is different. An arbitrator actually makes a decision. Both sides present their case, and the arbitrator decides who wins. In many situations, that decision is binding. That means you can't go to court afterward. You might not even realize this, but many contracts you sign include arbitration clauses. That gym membership you signed up for? Your cell phone contract? Your employment agreement? Read the fine print. Many of them say you must use arbitration instead of going to court. Know what you're signing. Always. Now here's something that has destroyed thousands of legitimate cases. It's called the statute of limitations. This is the time limit you have to file a lawsuit. Miss it, and your case is dead. Even if you're 100% right, even if you have perfect evidence. If someone crashes into your car and injures you, you might have 2 years to file a lawsuit in your state. If someone breaks a contract, you might have 4 to 6 years. If someone commits medical malpractice, it could be 1 to 3 years depending on the state. These deadlines are strict. There are some exceptions. If you didn't discover the injury right away, like finding out years later that a doctor left a surgical tool inside your body, the clock might start from the date you discovered the problem, not the date it happened. This is called the discovery rule. But don't count on exceptions. The moment you think you have a legal issue, start the clock in your head and act fast. Waiting can cost you everything. Let's talk about warrants, because the police cannot just do whatever they want. The Fourth Amendment of the U.S. Constitution protects you from unreasonable searches and seizures. That means, in most cases, the police need a warrant before they search your home, your car, or your belongings. A warrant is a document signed by a judge that gives the police permission to search a specific place for specific things. The police have to go to a judge and say, "We believe there are stolen electronics in this person's apartment, and here is our evidence for believing that." The judge reviews it, and if there's probable cause, they sign the warrant. But there are exceptions. If a police officer sees drugs sitting on your car's front seat during a traffic stop, they don't need a warrant. That's called plain view. If you're being arrested, police can search you and the area around you for their own safety. If someone is screaming for help inside a building, police can enter without a warrant under exigent circumstances. Knowing your rights around warrants is critical. If the police violate these rules, the evidence they find can get thrown out of court. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You've heard this on TV 1,000 times, but do you understand what it really means? These are called your Miranda rights, named after the 1966 Supreme Court case Miranda versus Arizona. The police must tell you these rights when you are in custody and being questioned. If they don't, anything you say might be thrown out of court. Here's what catches people. Many people think they need to talk to clear their name. They think silence makes them look guilty, but the opposite is true in court. Anything you say, even something innocent, can be twisted and used against you. Saying, "I was near that store last night," might sound harmless, but a prosecutor can turn that into evidence that you were at the scene of a crime. The smartest thing you can do if you're arrested is say these exact words: "I want a lawyer." Then, stop talking. That's not being difficult, that's being smart. Let's talk about something that can land you in jail, even if you haven't committed a crime. It's called contempt of court, and it's the judge's most powerful tool. Contempt of court means you did something that shows disrespect to the court or disobeyed a court order. If a judge orders you to pay child support and you refuse, that's contempt. If you start screaming and cursing during a hearing, that's contempt. If you're a witness and you refuse to testify after being subpoenaed, that's contempt. There are two types. Civil contempt is meant to force you to do something. The judge might say, "You will stay in jail until you hand over those financial documents. Once you comply, you're free." Criminal contempt is a punishment for what you already did. The judge might sentence you to 30 days in jail for disrupting the courtroom. Understanding contempt is important because the judge has wide power here. They can lock you up on the spot. No separate trial needed. Here's something nobody likes talking about. Court costs money. Even if you're in the right, accessing justice has a price tag. There are filing fees to start a case, fees for serving documents, fees for depositions, expert witness fees, and of course, attorney fees. Filing a civil lawsuit can cost anywhere from $50 in small claims court to $400 or more in federal court. Hiring an expert witness to testify that a product was defective might cost $5,000 to $20,000. A full trial with lawyers, experts, and months of preparation can cost hundreds of thousands of dollars. But there are ways to reduce these costs. If you can't afford the filing fees, you can ask the court for a, quote, fee waiver. Courts grant these to people with low incomes. You fill out a form showing your financial situation, and if you qualify, the court waives the fees. Also, many lawyers work on payment plans. And as I mentioned earlier, personal injury lawyers often work on contingency, meaning you pay nothing unless you win. The system is expensive, yes, but there are doors. You just need to know where to knock. If you're charged with a crime and can't afford a lawyer, the court will appoint a, quote, public defender for you. These are real lawyers. They went to law school. They passed the bar exam. They work full-time defending people who can't afford private attorneys. But here's the problem. Public defenders are massively overworked. In many areas, a single public defender handles 150, 200, sometimes 300 or more cases at the same time. Imagine trying to give your best effort on 300 different cases. It's nearly impossible. This doesn't mean public defenders are bad. Many of them are excellent. But the system gives them too many cases and not enough resources. And here's something many people don't know. You don't always qualify for a public defender. The court looks at your income. If you make too much money, even if you can't afford a private attorney, the court might say you don't qualify. You're stuck in the middle. Too rich for free help. Too poor to hire someone. This is the gap in the system that traps millions of people. Most civil cases never go to trial. They end in a settlement. A settlement is when both sides agree to resolve the case without a judge or jury making the decision. The plaintiff usually agrees to accept a certain amount of money, and the defendant agrees to pay it. Imagine you slipped and broke your hip in a grocery store because they failed to clean up a spill. Your medical bills are $80,000. You sue. The grocery store's insurance company offers you $120,000 to settle. You think about the risk of trial, the time it would take, the possibility of losing and getting nothing, and you accept. Settlements are private. Unlike trials, which are public, settlements can include confidentiality agreements. That means neither side can talk about how much money was paid. That's why you hear about big lawsuits in the news, but never find out what happened. The company paid money. The person agreed to stay quiet. Case closed. About 95% of civil cases settle before trial. Understanding how settlements work puts you in a better position to negotiate one. If someone is threatening you, harassing you, or physically hurting you, the court can issue a protective order. Some people call it a restraining order. It's a court order that tells the other person to stay away from you. If your ex-partner is showing up at your job, sending threatening messages, or following you, you can go to court and ask for a protective order. In most states, you can get a temporary order very quickly, sometimes the same day you ask. Then, the court schedules a hearing where both sides can speak, and the judge decides whether to make it permanent. Violating a protective order is a crime. If the order says your ex must stay 500 feet away from you and they show up at your door, they can be arrested. On the spot. The order gives the police power to act, but you have to get the order first. The court won't issue one on its own. You have to ask. And you should never feel embarrassed about asking. This is the court protecting your safety. That's exactly what it's there for. Juvenile court handles cases involving minors, typically people under 18 years old. The philosophy behind juvenile court is different from adult court. The idea is that young people can be rehabilitated. They can change. So the focus is more on helping them than punishing them. If a 15-year-old is caught shoplifting, they usually won't go to an adult prison. They might get community service, counseling, probation, or placement in a juvenile facility. The goal is to get them back on track, not to ruin their future. But there are exceptions. For very serious crimes, a juvenile can be, quote, tried as an adult. If a 16-year-old commits a violent armed robbery, the prosecutor can ask the court to transfer the case to adult court. If that happens, the teenager faces adult sentences, adult prison, and an adult criminal record. Juvenile court records are usually sealed, meaning they don't follow you into adulthood. But once you're tried as an adult, that protection disappears. Parents, talk to your children about the law. It can save their lives. Now let me give you some practical advice. If you ever step foot in a courtroom, you need to know how to behave, because how you act in court can actually affect your case. First, dress properly. Wear what you'd wear to a job interview. No flip-flops, no torn jeans, no hats. Judges notice. Juries notice. Second, be on time. If your hearing is at 9 a.m., be there at 8:30 a.m. Being late can result in a default judgment against you, which means you lose simply because you didn't show up. Third, always address the judge as Your Honor. Never interrupt. Never argue with the judge. If you disagree, your lawyer can raise an objection. If you don't have a lawyer, you can calmly say, Your Honor, I respectfully disagree. Fourth, turn off your phone. A ringing phone in a courtroom can get you held in contempt. And finally, stand up when the judge enters and when the judge leaves. It's a sign of respect. These small things matter. Judges are human, and humans respond to respect. Everything that happens in court is recorded and becomes part of the court record. This includes all the documents filed, the transcripts of what was said, the evidence presented, and the judge's decisions. In most cases, court records are public. That means anyone can look them up. Your divorce filing? Public. Your lawsuit against your neighbor? Public. A criminal charge against you? Public. This is why some celebrities and wealthy individuals fight so hard to settle cases privately, because once something is in the court record, it's there forever. You can, in some cases, ask the court to seal records. Sealing means the public can't see them. This is more common in juvenile cases, certain family matters, and cases involving victims of sexual assault. In criminal cases, some states allow you to expunge your record, which means the conviction is erased. But the rules are different in every state. Understanding court records matters because in today's world, employers, landlords, and even dates can search your name and find your court history. Knowing this helps you make informed decisions. Here's a rule that protects you in a big way. It's called double jeopardy. The Fifth Amendment says the government cannot try you for the same crime twice. If you go to trial for robbery and the jury says not guilty, the government cannot come back and try you again for that same robbery. It's over. But there's a catch. The Department of Justice clarifies that the principle of double jeopardy does not apply between state and federal courts. So if the state of Georgia acquits you of a crime, the federal government can still file charges if that same act also violated federal law. They're considered separate governments. Also, double jeopardy only applies to criminal cases. It doesn't apply to civil cases. So someone found not guilty of murder in criminal court can still be sued in civil court by the victim's family. That's exactly what happened in the famous O.J. Simpson case. He was acquitted of murder in criminal court, but found liable in civil court and ordered to pay $33.5 million. Two different courts, two different results, two different standards of proof. Habeas corpus. These two Latin words are one of the most powerful legal tools in existence. Habeas corpus literally means produce the body. It's a court order that forces the government to justify why they're holding someone in jail or prison. If someone is locked up and they believe they're being held illegally, like if they were imprisoned without a proper trial, or if new evidence proves they're innocent, they can file a writ of habeas corpus. This forces the government to come to court and prove they have a legal right to keep that person behind bars. Habeas corpus is so important that it's mentioned in the U.S. Constitution itself. It's been called the Great Writ. It's the ultimate check on government power. Without it, the government could lock people away and throw away the key. No explanation, no trial, no accountability. Habeas corpus says, no, you must justify this. It has freed innocent people from death row. It is one of the oldest legal protections in the world, going back to English law over 800 years ago. A grand jury is different from a regular jury. A regular jury, also called a petite jury, decides whether someone is guilty or not guilty at trial. A grand jury decides whether there's enough evidence to formally charge someone with a crime in the first place. Grand juries are made up of citizens, usually 16 to 23 people. The prosecutor presents evidence to them in secret. There's no judge, there's no defense lawyer. The accused person usually isn't even there. The grand jury then votes on whether to issue an indictment, which is the formal charge. There's an old saying among lawyers, a grand jury would indict a ham sandwich. That means grand juries almost always agree with the prosecutor. Why? Because they only hear one side of the story, the prosecution's side. The defense doesn't get to present their case at this stage. Grand juries are used in federal cases and in some state cases. Not all states require them. Understanding this process is important because if you're ever told you've been indicted, it doesn't mean you're guilty. It just means the prosecution convinced a group of people that there's enough evidence to bring you to trial. If someone is found guilty at trial or pleads guilty, the next step is sentencing. This is where the judge decides the punishment, and sentences vary wildly depending on the crime, the state, and the judge. For a first-time shoplifting offense, you might get probation, community service, and a fine. For armed robbery, you might get 5 to 20 years in prison. For murder, you could get life in prison, or, in some states, the death penalty. Judges usually have a range they can sentence within, called sentencing guidelines. But judges also consider mitigating factors and aggravating factors. Mitigating factors are things that work in your favor, like having no prior criminal record, cooperating with the investigation, or showing genuine remorse. Aggravating factors work against you, like using extreme violence, targeting a vulnerable person, or having a long criminal history. Sentencing is not random. It follows a logic. And understanding that logic can help you or your lawyer make the strongest possible argument for a fair outcome. Probation and parole. Two words that people confuse all the time. Probation is instead of jail. Parole is after jail. Let me explain. Probation means the judge says, "I'm not sending you to jail, but you must follow these rules for the next 2 years. Check in with a probation officer once a month. Don't commit any new crimes. Don't leave the state without permission. Pass drug tests. If you follow all the rules, you stay free. If you violate any of them, the judge can send you to jail immediately." Parole is different. Parole happens after you've already served part of your prison sentence. A person sentenced to 10 years in prison might be eligible for parole after serving 5 years. A parole board reviews their behavior in prison and decides whether to let them out early under supervision. If they violate the conditions, they go back to prison to serve the rest of their original sentence. Both probation and parole are about conditional freedom. The conditions are the key. Break them, and the freedom disappears. Now, what happens to your criminal record? Because a criminal record follows you everywhere. It affects your ability to get a job, to rent an apartment, to get a professional license, to vote in some states. It's like a chain tied to your ankle for the rest of your life. But in many states, there is a way to break that chain. It's called expungement. Expungement means the court seals or destroys your criminal record so that it no longer shows up in background checks. Not all crimes can be expunged. Violent felonies usually can't. But many misdemeanors and lower-level offenses can be. To get an expungement, you usually have to wait a certain number of years after completing your sentence, stay out of trouble, and file a petition with the court. Some states have made this process easier in recent years with clean slate laws that automatically expunge certain records after a period of time. If you have a criminal record that's holding you back, look into your state's expungement laws. It could open doors you thought were permanently closed. You've probably heard the term class action lawsuit, but maybe you're not sure what it means. A class action is when a large group of people who all suffered the same harm from the same company or person join together to file one lawsuit. Imagine a company sells a medication that causes liver damage. Instead of 10,000 people each filing their own separate lawsuit, they band together into one big case. That's a class action. It's more efficient, it saves time, and it gives small claims real power. Because one person suing over $500 in damage might not be worth a lawyer's time. But 10,000 people each suing over $500? That's $5 million. Class actions have forced some of the biggest companies in the world to pay billions of dollars. Tobacco companies, pharmaceutical companies, tech companies. If you've ever received a random check in the mail for $12 or a notice saying you're eligible for a payment from a lawsuit you never heard of, that was a class action settlement. Don't throw those notices away. That's your money. Let me give you a quick crash course on legal terms that you'll hear in any courtroom. Because half the confusion comes from not knowing what these words mean. Plaintiff means the person who starts the lawsuit. Defendant means the person being sued or accused. Counsel means a lawyer. Sustained means the judge agrees with an objection. Overruled means the judge disagrees with the objection. Deposition means a recorded, sworn interview outside of court. Subpoena means a court order to appear in court or produce documents. Affidavit means a written statement made under oath. Tort means a wrongful act that causes harm. Litigation means the process of taking a case through court. Stipulation means both sides agree on a certain fact. Restitution means paying back the victim. Injunction means a court order telling someone to do or stop doing something. Learn these words. Write them down. They will make every courtroom interaction less confusing and less scary. If I could give you just one piece of advice from this entire video, it would be this: document everything. Every conversation, every receipt, every email, every text message, every photo, everything. If your landlord refuses to fix a leaking roof, don't just call them. Send an email. Then take a photo of the leak every day. Then save every text message where they promise to fix it but don't. Because when you end up in court, it's your word against theirs. And the person with the most documentation almost always wins. A man once won a $30,000 case against a contractor who did terrible renovation work on his house. How? He took photos every single day of the construction. He saved every email and text. He kept every receipt. When the contractor tried to lie in court and say the work was done properly, the man pulled out his phone and showed 200 photos proving otherwise. Case 1. The paper trail is your best weapon. Start creating one the moment you suspect a problem. Your rights are only as powerful as your knowledge of them. If you don't know your rights, they might as well not exist. So let me give you the essential ones. You have the right to remain silent. You have the right to an attorney in a criminal case. You have the right to a speedy trial. You have the right to confront your accusers. You have the right to a jury of your peers. You have the right against unreasonable searches. You have the right against cruel and unusual punishment. You have the right to not testify against yourself. These rights come from the Bill of Rights, the first 10 amendments to the U.S. Constitution. They are not suggestions, they are guarantees. If a police officer tries to search your car without a warrant or probable cause, you can calmly say, "I do not consent to a search." That one sentence activates your Fourth Amendment right. If a detective starts asking you questions after an arrest, you can say, "I want a lawyer." That one sentence activates your Fifth and Sixth Amendment rights. Words are weapons in the legal system. Learn yours. Now let me tell you the mistakes that people make all the time. Mistakes that cost them their cases. Mistake number 1, talking to the police without a lawyer. I said it before and I'll say it again. Do not talk to the police without a lawyer present. You are not going to explain your way out of anything. Mistake number 2, missing deadlines. Statutes of limitations, filing deadlines, response deadlines. Miss any of them and your case could be thrown out or decided against you automatically. Mistake number 3, not reading what you sign. How many people sign apartment leases, employment contracts, or medical forms without reading a single word? Those documents often contain clauses that limit your right to sue, force you into arbitration, or waive your claims. Mistake number 4, posting on social media during a case. Someone sued a company for a back injury claiming they couldn't walk properly. Then they posted a video of themselves dancing at a party. The defense lawyer found it, case destroyed. If you're in any kind of legal dispute, go silent on social media. Don't post, don't comment, don't share. Assume the other side is watching, because they are. Now, the concepts we've covered mostly apply to the American system. But courts exist in every country. And while the details differ, the core ideas are similar. Most countries have trial courts, appellate courts, and a highest court of last resort. Some countries use common law systems, like the United States, the United Kingdom, Canada, and Australia. These systems rely heavily on past decisions by judges, called precedent. If a judge in London ruled a certain way 50 years ago, courts today might follow that same ruling. Other countries use civil law systems, like France, Germany, Japan, and most of Latin America. These systems rely more on written codes and statutes than on past judicial decisions. There are also international courts. The International Court of Justice in The Hague handles disputes between nations. The International Criminal Court prosecutes individuals for crimes like genocide and war crimes. Understanding that different countries have different legal systems is especially important if you do business overseas, travel frequently, or have family in other countries. The rules change when you cross a border. Courts are changing fast. Technology is transforming how the legal system works. During the COVID-19 pandemic, courts started using video hearings, and many have kept them. Now you can attend certain hearings from your living room through Zoom or other platforms. Electronic filing, or e-filing, means you can submit court documents online instead of physically going to the courthouse. Many states now have online portals where you can check the status of your case, view documents, and track deadlines.
And artificial intelligence is starting to enter the legal world too. AI tools can now review thousands of documents in hours instead of weeks. Some courts are experimenting with AI to help predict case outcomes and set bail amounts. This raises big questions about fairness and privacy. But the trend is clear. Technology is making courts more accessible while also creating new challenges. Stay informed, because the court system of tomorrow will look very different from the one we have today. Let me give you some concrete resources, because knowledge without action is useless. If you need legal help, start with your state's legal aid website. Every state has one. Just search Your State Legal Aid online. The Legal Services Corporation is the largest funder of civil legal aid in the country. They support 129 legal aid organizations across all 50 states. LawHelp.org connects low-income people with free legal resources in their area. Many courthouses also have self-help centers, where you can get guidance on filling out forms and understanding procedures.
Your local bar association can connect you with lawyers who do pro bono work, meaning they help people for free. Law school clinics are another great option. And don't forget about online resources. Websites like nolo.com, findlaw.com, and even your state court's official website often have free guides, forms, and explanations. The help exists. You just need to reach for it. No more excuses, no more confusion, just action. If you're a parent, teach your children about the legal system early. Don't wait until they're in trouble. The American Bar Association noted that there's a common idea that young people should be protected from learning about the legal system because it's too heavy. But the reality is, young people are already inside the system. They're being stopped by police. They're being charged as adults. They're experiencing crime in their neighborhoods. Teaching a 14-year-old what their rights are during a police stop is not scary. It's life-saving. Teaching a 16-year-old what a lease says before they sign their first apartment is not boring. It's empowering. Teaching a 12-year-old the difference between criminal and civil court is not complicated. It's necessary. The American Bar Association also found that there is no neuroscientific or psychological evidence suggesting teenagers are unable to understand these issues. They can handle it. They need to know it. The legal system doesn't care about age, so neither should your education. One more thing. The Willow Research Study found that only about 1/3 of Americans express confidence in the courts. A majority believe that wealthy parties have an advantage while the poor and minorities are at a disadvantage. And the study found something even more striking. A majority of millennials and Generation Z believe court decisions should reflect public opinion. Now, I'm not here to tell you the system is perfect. It's not. The IAALS found that 80% of the civil legal needs of the poor go unmet. The system has cracks, big ones. But understanding the system gives you the power to navigate those cracks instead of falling into them. Trust the system enough to use it, but verify everything. Get your own lawyer. Read your own documents. Know your own rights. Don't depend on anyone else to protect your interests inside a courtroom. That's your job. And now, you have the tools to do that job. Here's something that makes the entire legal system work. It's called precedent. Precedent means that courts look at past decisions when making new decisions. If a similar case was decided a certain way before, courts tend to follow that same reasoning. This is why the Brown versus Board of Education case in 1954 was so important. The Supreme Court ruled that racial segregation in schools was unconstitutional. That one decision set a precedent that affected every school in the country. Every court in America had to follow it. Precedent creates consistency. It means the law isn't random. If you can find a case similar to yours where the person won, you can argue that the court should decide your case the same way. Your lawyer does this all the time. They research past cases, find favorable decisions, and present them to the judge. This is called case law, and it's one of the most powerful tools in the legal system. Knowing that the law is built on past decisions helps you predict what future decisions might look like. The best legal strategy is to never need one. Prevention is always cheaper, faster, and less stressful than litigation. So let me give you some actionable prevention steps. Always read contracts before signing. Whether it's an apartment lease, an employment agreement, or a terms of service page online, know what you're agreeing to. Always keep records. Save receipts, emails, texts, and photos related to any transaction or relationship that could go wrong. Create a file. Keep it organized. Always consult a lawyer before you have a problem, not after. Many lawyers charge modest fees for quick consultations. Getting a lawyer to review a business contract before you sign it costs a few $100s. Getting a lawyer to sue someone after the contract goes wrong costs tens of thousands. An ounce of prevention is worth a pound of cure. This old saying is especially true in law. Be proactive, be prepared, and you'll spend far less time inside a courtroom. Let me bring it all together. You now know that there are two court systems, federal and state. You know the difference between criminal and civil cases. You know what jurisdiction means and why it matters. You know how trials work from start to finish. You know about plea bargains and why 98% of cases never go to trial. You know your Miranda rights. You know about warrants, evidence, burden of proof, and the appeals process. You know about small claims court, family court, probate court, and bankruptcy court. You know how to find a lawyer, how legal aid works, and why self-representation is risky. You know about settlements, protective orders, statutes of limitations, and expungement. You know more about how courts work than the majority of people walking around today. Remember that Harris Poll study we started with? More than half of Americans don't even understand their basic rights in court. You are no longer one of them. That's powerful. And that knowledge is going to protect you, your family, and your future. So, what do you do now? First, share this video with someone you love, because the person you share it with might be the one who needs it most. Second, go look up your state's legal aid resources today. Bookmark them. Save them, just in case. Third, start documenting. Create a folder on your computer called Legal Records. Put your lease in there, your employment contract, your insurance policy, photos of your property, records of important conversations. Build that paper trail before you need it. And fourth, if you have a legal issue right now that you've been ignoring, stop ignoring it. Check the statute of limitations. Make one phone call to a lawyer. Take one step. Because here's the truth. The court system, it doesn't care if you don't understand it. It will move forward without you. Deadlines will pass. Judgments will be entered. Rights will be waived. And by the time you realize what happened, it could be too late. But not for you. Not anymore. You watched this entire video. You learned. And learning is the first step to winning. Now go protect yourself.